Money Radio, thank you for joining us. It's always a pleasure to get together with Laura Bramnick from TalkRealEstateAZ.com. Laura, good afternoon.
Good afternoon, St. Clair.
So good to see you again.
It's great to be back.
Laura, we're going to be talking about deal breakers. And this is an area that is very important, particularly from a buyer's perspective.
Yes.
To understand the negotiations and what can go wrong.
And what you can ask for.
Yes, yes. If you'd like to talk with Laura Bramnick, she is at TalkRealEstateAZ.com. You can also listen to archived audio of our conversations with Laura at TalkRealEstateAZ.com. You can call 480-624-2705, 480-624-2705. Laura is a lawyer, and she is also a real estate agent and a consumer advocate. She works in residential and commercial real estate, holds an active Arizona real estate license, licensed by the bar in Arizona, certified instructor with the Arizona Department of Real Estate. Now, Laura, when it comes to negotiating a real estate transaction, there are a lot of things that can just ruin a deal.
Yeah, I think people tend to go into it too casually.
Mm-hmm.
And although most transactions are fairly smooth, there's a high enough percentage that aren't, that you really need to spend a little time thinking about what you really want out of the transaction, what the possible deal breakers can be. And so I've kind of made a laundry list of what I see in my practice. And something as simple as, does the seller have title to sell the property? And by that I mean there are certain red flags. That doesn't mean that they don't have title if one of these red flags comes up, but it means you need to ask some questions. If the owner of the property is an LLC,
Okay.
you need to make sure, you want to see documents, who's going to sign on behalf of the LLC, and you want to cross-reference that with what the name is on the title, what the name is on the listing agreement, what the name is on the contract.
And you might want to put something about that in the contract
Exactly,
itself.
that you want to make sure that the person is signing. We just had a transaction held up for about 2 months in my office over just that, where one LLC was not functional, even though it hadn't been properly closed. And it was an out-of-state LLC. And we actually had to track down, and then it was transferred to another LLC. We actually had to track down the original principals. The title company would not insure the title without getting their signature, that they were actually the principals of the LLC, that it was no longer functional, and it hadn't been legally closed.
And that, of course, could break a deal, or it could add extra expense, and then if you don't have it in the contract of who would incur that expense or who would have some liability for breaking the deal.
Yes. Now, had we had conditions in there, I think it would have been helpful that at least the buyer would have had some protections in terms of if it's delayed, if you don't have proper title, maybe maybe the price would be reduced, or you would have to pay some of my costs. The other red flag is when a trustee is selling a property. I just had a case where
the owner has passed away and now the trust is selling a property.
Yeah, and it's not unusual that people have a living trust where the property's in the name of the trust.
Sure.
But in the case that I had recently, the owner had passed away, and the agent and the seller had assumed that the trustee, or the person who said they were the trustee, had the authority to sell, when in fact there was not a trust, there was a will. And a will is a whole different thing. I know you and I have talked about going through probate.
A will means that the real estate will have to go through probate.
It means that you have to get court's permission, and
Right.
that takes money and time.
Yes.
And so the person that signed the contract actually had no legal authority to do so.
And sometimes there may be a living trust, but one particular piece of property may not necessarily be included in the trust.
That's right. So you want to ask some questions, or you want to put in the contract that this assumes that the person that's signing as seller has legal authority to do so, and if not, they're going to pay any costs incurred. Like, my client had incurred appraisal costs and loan costs up to the tune of almost $1,000.
Okay.
And to them, it wasn't a huge amount of money, but they had to move to Arizona and they needed that house. They had a disabled son.
Timing is important.
And you know what I'm saying? So everybody has different circumstances.
I'm thinking of another one now that you mentioned that, divorce cases.
Yes, divorce cases, and you many times maybe one party's on the loan, but both parties are on title, or one party's on the loan and but that doesn't mean that the other party has signed off on the property. You know,
Right.
we're a community property state. And although one party can sign a listing agreement, you need both parties to actually sell the property. And you as a buyer, you may not be aware of that. And you can get caught in the middle of all that.
And a standardized contract may not include some of these extra things that you can just put in for your own protection.
Yeah, you just need to ask some questions ahead of time. They're standard questions. We do have a template that realtors use that I think is an outstanding template, but each contract is unique, which is why it's important to meet with a lawyer and go over it before you sign it. It doesn't take that much extra time.
And you can add to it.
You can add to it, and don't be afraid to negotiate terms. If you assume the other party is going to say no, you've kind of made the decision for them.
Yeah, if you don't ask, you won't get.
You don't know what's important. Some people, certain specific items in the contract are not important to them. They're willing to acquiesce, you know, on those issues.
This is why it's just so important to have a real estate attorney that can assist you with the negotiations on residential or commercial real estate. It just makes so much sense. And Laura Bramnick, as I mentioned before, is a real estate attorney and a real estate agent as well. So she can do it both, and sometimes no extra cost involved.
Sometimes no extra cost, that's correct.
480-624-2705, 480-624-2705, talkrealestateaz.com. That'll put you in touch with Laura Bramnick. She answers her own phone, 480-624-2705. Thank you so much, Laura.
Thanks, Sinclair.